as a root problem. He doesn't make any argument that anything in the deposition is sensitive or private in nature. In other words, he doesn't really make any real arguments as to why this entire deposition should be treated as confidential. For starters, he addresses Logan Paul's argument that Coffeezilla failed to essentially try to work things out with him before resorting to the official objection process here. Like I said in my last video, if it's clear early on that going back and forth in the meet and confer process is just going to be a total waste of time, Coffeezilla isn't required to keep engaging with Logan Paul.
Before we even get into this, have you ever seen someone try so hard to shut down criticism that it actually makes them look even more exposed? Because that's exactly what's unfolding right now. This lawsuit was supposed to be Logan Paul's big reset, the comeback moment, the chapter where he clears his name and proves the critics wrong once and for all. Instead, it's turning into one of the most damaging chapters of his entire career. Not because of a new controversy, not because of leaked texts, but because Logan Paul is now pushing to keep what he said under oath completely hidden from the public. And when someone with this level of influence is fighting that hard for total secrecy, it raises serious questions. Something clearly didn't go the way he expected. This all traces back to Logan Paul's defamation lawsuit against Coffeezilla. Logan believed taking legal action would shut the criticism down. The idea seemed simple. Apply pressure, make it expensive, make it uncomfortable, and the criticism fades away. But that plan flipped fast. Instead of silencing the situation, the lawsuit forced Logan into a formal deposition, where he had to answer questions under oath. Now here's where things get intense. Logan isn't asking for a small portion of that deposition to stay private. He's not asking for a few lines to be blacked out. He wants the entire thing sealed. Every page, every answer, every second of it. Completely confidential. Normally, when someone asks a court to seal testimony, they point to very specific reasons. They might say a section includes medical records or private family matters.
Anyway, Coffeezilla then addresses Paul's next argument, the one where Paul complains about Coffeezilla sharing information with the FBI and with the CryptoZoo class action plaintiffs. And so here's where I think Coffeezilla lays down some strong hints as to what it is that Logan Paul is so afraid of getting out from his deposition.
Or sensitive financial details, that's standard. But asking to lock away the whole thing, that's not common. And that's why people are paying very close attention to what's happening next. This next part really changes the tone. Logan did not point to one specific sentence that needed protection. Not one line, not one paragraph. He didn't identify a single piece of clearly sensitive information. Instead, he simply argued that the entire deposition should be hidden from public view. All of it. No breakdown, no explanation. Just seal the whole thing. According to Logan's legal team, the concern is not about medical records or private family details. Their main claim is that Coffeezilla cannot be trusted with the transcript. They argue that if it is not sealed, Coffeezilla could share it publicly. He could discuss it with other attorneys. He could even provide it to investigators. And in Logan's view, that possibility makes sealing the entire deposition necessary. Here's where the legal tension kicks in. Sharing lawfully obtained information within legal boundaries is not automatically improper. There is no universal rule that discovery material must stay secret forever. There is no blanket law that says you cannot talk about it. And there is no automatic prohibition against providing information to law enforcement if someone believes it is relevant. Courts do not seal documents simply because someone feels uncomfortable. Embarrassment is not a legal standard. Looking inconsistent under oath is not a legal standard. Regretting how something sounded later is not a legal standard either. Coffeezilla's legal team makes that argument very directly. They state that unless the deposition includes genuinely private, protected, or legally sensitive material, there is no basis to hide it from the public record. If Logan contradicted earlier statements, that alone is not grounds for sealing. If he avoided questions, that is not grounds either.
And he also responds to Paul's argument about sharing information with the CryptoZoo class action plaintiffs as well. Specifically, he says, Paul also suggests Coffeezilla is improperly sharing confidential information with counsel in the class action, citing a YouTube video in which class action plaintiffs counsel claims Paul's defamation case was helpful to the class action case. Paul omitted from his motion what class action counsel found so helpful.
If he made admissions that complicate his own case, that is still not a valid reason to seal the transcript. That is the purpose of a deposition. It is a structured legal process where questions are answered under oath. It is meant to clarify facts, test consistency, and document testimony. It is not a press interview. It is not a podcast. It is not a place where someone can reshape the narrative in real time. And this is where the situation becomes uncomfortable for Logan. He is not arguing that the deposition exposes someone else's private information. He is arguing that the deposition itself is dangerous because of what it reveals about him. That distinction matters. Courts typically protect personal privacy or trade secrets, not reputational discomfort. Coffeezilla's attorneys push back strongly on this point. They state that Logan has not identified a clear, good faith reason for sealing the document. He has not explained why any specific section qualifies as confidential. Instead, he wants the entire transcript removed from public access. And that is not how the legal system usually operates. Judges expect specific justifications, not broad requests without detail. At this stage, it starts to feel less like legal protection and more like damage control. Because if the deposition strengthened Logan's position, there would likely be no rush to hide it. If it showcased confidence and consistency, it could be used as a public relations win. Clips would be highlighted, timestamps would be referenced, it would become part of the defense narrative. Instead, the push is for total secrecy, and that is what people are noticing. Depositions are not social media posts. They cannot be edited for tone. They cannot be reshot. They are transcripts of exactly what was said in full context under oath. If that transcript ever becomes public, it will stand on its own. No filters.
So his third argument basically says that Coffeezilla hasn't indicated any imminent need to file any portion of Paul's deposition transcript. And he says Coffeezilla also hasn't explained how designating the deposition as confidential otherwise impacts Coffeezilla's ability to litigate the case. But that's not a reason to mark evidence as confidential.
No framing, just the record. And if Logan Paul is this determined to prevent anyone from reading his own sworn testimony, it suggests that the outcome may not have aligned with his expectations. Now we reach the part where his argument starts to unravel even more. Logan's second major claim for sealing the deposition centers on the idea that Coffeezilla has shared information from the lawsuit with federal investigators, including the FBI. Based on that, Logan argues that Coffeezilla cannot be trusted with access to the transcript. Think about that reasoning. The claim is that because someone might provide information to investigators, that person should not be allowed to access or discuss discovery material. That logic raises serious legal questions. Courts generally do not restrict access simply because information could be reviewed by authorities. Reporting concerns to investigators in itself is not automatically wrongdoing. And this is where the debate intensifies, because once the argument shifts from privacy to control, the focus changes entirely. It becomes less about protecting sensitive data and more about managing who sees what. And that is when the legal filings begin to paint a very different picture of what this fight is truly about. That is simply not how the legal system works unless there is a clear, specific protective order that blocks someone from doing so. Sharing lawfully obtained information with law enforcement is generally allowed. In some situations, it can even be encouraged if there are concerns about potential misconduct. Coffeezilla's legal team makes that point directly in their response. They argue that if discovery reveals possible fraud or other questionable activity, bringing that information to authorities is not improper.
Looking at this list of categories for protection and looking at how in his motion Logan Paul doesn't claim that any of the information triggers any kind of privacy right, whether that's his or some third party, again, unless I'm missing something really important here that, it happens as much as I hate when it does, I don't see anything in this motion that tells me, yeah, there's some reason to keep this confidential. So at the end of the day, I'm thinking this is pretty likely that it's going to be denied and that the deposition is likely to get shared. And I'll just say, if this deposition does find its way to the internet, I, for one, would be very interested in watching the playback.
It can serve the public interest, and this is where Logan's position starts to weaken. Because during this same case, Logan's own legal team contacted federal investigators and referenced discovery materials. So the argument begins to sound uneven. It shifts from a legal principle to a matter of who gets to control the narrative. Logan's stance starts to feel less about fairness and more about limiting where information might travel. The concern does not seem to be that investigators are involved in general. The concern appears to be about what investigators might see inside that deposition transcript. That difference is important. Next, Logan turns to the protective order. He argues that there is already a protective order in place and suggests that Coffeezilla is violating the spirit of that order by discussing information outside of the lawsuit. On the surface, that sounds serious. But when you actually look at what a protective order is designed to do, the picture changes. A protective order is not a blanket gag rule. It does not automatically silence everything connected to a case. Its purpose is to shield specific categories of information that qualify as confidential under defined terms. That usually includes private medical data, sensitive financial records, trade secrets, or personal identifiers. It does not automatically apply to anything that might be uncomfortable or damaging from a public relations standpoint. Coffeezilla's attorneys point out that the protective order in this case.
And so on January 9th, Coffeezilla responded with his opposition to the motion to preserve confidentiality, and here he didn't disappoint. For starters, he said Logan Paul designated his entire deposition confidential, citing the court's confidentiality and protective order. That order allows a party to designate as confidential only such information that the party in good faith believes in fact is confidential. Paul has not provided, and indeed cannot provide, any good faith basis to keep his entire deposition confidential. Nor has he explained why any specific portions of his deposition are actually confidential, as that term is defined in the protective order.
And here is the part Logan
restricts only material that truly meets the confidentiality definition outlined in the agreement. And once again, Logan does not identify a single portion of the deposition that falls under that definition. Not one page, not one name, not one detailed example. The request remains broad and undefined. Courts do not operate on assumptions or impressions. They rely on clear written standards. And based on what has been filed publicly, the written standards do not automatically justify sealing the entire transcript. Then another argument surfaces. Logan claims that Coffeezilla shared discovery materials with attorneys involved in the CryptoZoo class action lawsuit and presents that as an abuse of process. But in legal practice, when two cases involve overlapping projects, similar claims, or related parties, sharing non-confidential information between legal teams is not unusual. It happens regularly, especially when the material in question is already public or later becomes part of the court record. There is also an important detail here. Much of the information Logan objects to had already appeared in public filings. Court documents are accessible records. They are not secret leaks. When something is part of the public record, discussing it does not automatically violate a protective order. At this stage, a pattern becomes difficult to ignore. The issue does not appear to center on private medical files or sensitive family matters. It appears to focus on controlling how information moves once it enters the legal system.
Coffeezilla is not a criminal. I called him, I apologize. Step 2, we want to offer a rewards program for players who are disappointed in the status of the game. So essentially you're gonna be able to burn your base egg or your base animal for the mint price, which was 0.1 ETH or the equivalent in BNB. I am personally committing 1,000 ETH to this, which is about $1.3 million. I'm sorry guys, I apologize for how this has unfolded thus far, and I want people to know that they can trust me and that I'll always take care of the fans and people who support me. And lastly, thank you, Coffeezilla. You have catalyzed this, and I am very grateful for your work and your investigation, and I mean that. Thank you, bro.
And if those answers do not line up with years of public statements, apologies, and promises, the fallout is unavoidable.
If the deposition contains statements that differ from prior public comments, that could create ripple effects in other ongoing disputes. And that is where the urgency begins to look strategic. If the transcript reinforces other claims or strengthens separate lawsuits, it expands the scope of impact. The case stops being contained to one courtroom. It becomes part of a larger legal conversation. The more aggressively the push for secrecy continues, the more observers question the motive behind it. Because if the deposition were routine and uneventful, there would likely be little reason to seek total confidentiality. Efforts to seal every page of testimony can signal that the content itself carries weight. At this point, the debate is no longer just about privacy. It is about transparency, consistency, and the role sworn testimony plays in shaping broader legal outcomes. And the harder the resistance becomes, the more attention the transcript seems to attract. At this point, the fight does not feel like it is about defamation anymore. It feels like it is about containment. The focus has shifted from defending statements to controlling exposure. And that is why this situation stretches far beyond one lawsuit. If the deposition becomes public, it does not just influence this case. It could ripple into other legal matters connected to CryptoZoo. It could affect how the public views the entire project. It could impact the image Logan has worked carefully to maintain. That broader impact is what makes this moment so significant. Now we get to what many observers consider Logan Paul's weakest argument. He claims that Coffeezilla has not demonstrated any urgent need to use the deposition publicly. Because of that, Logan argues there is no reason for it to ever be released. In simple terms, the position is, if no one urgently needs it right now, it should stay hidden. But public access to court records does not work that way. The burden is not on someone else to prove why the public should see a transcript. The burden is on the party requesting secrecy to prove why it should be sealed. Transparency is generally the starting point. Confidentiality requires a clear justification, and that is where the filings become critical. Logan does not identify a specific page that contains private medical data. He does not highlight a paragraph with confidential trade information. He does not point to a single line that falls under a recognized category of protected material. Instead, the request remains broad. Seal the entire deposition. Courts typically require more than that. Judges expect concrete reasons tied to defined legal standards. Vague concerns about potential reputational harm do not usually meet those standards. Feeling uncomfortable about how testimony may be interpreted is not the same as demonstrating legal confidentiality. Legal analysts who reviewed the motions have pointed out that sealing requests must be narrow and specific. Courts do not hide sworn testimony simply because it could generate negative headlines. They do not restrict access solely to preserve someone's public image. The legal threshold is higher than that. What complicates matters further is the contrast between courtroom privacy and public messaging. While seeking to seal the deposition, Logan has also spoken publicly about the lawsuit online. He has shared his perspective, explained his position, and framed the narrative for millions of viewers. Those videos gain significant traction. That contrast creates tension. On one hand, there is a request for confidentiality when the transcript is outside of personal control. On the other hand, there is active public discussion when the messaging can be shaped directly. Observers have noted that this difference makes the privacy argument harder to sustain. There is also prior context that adds another layer. In earlier public statements, Logan acknowledged problems with CryptoZoo. In an apology video, he thanked Coffeezilla for highlighting issues with the project. He stated that he intended to make things right and spoke about refund plans. Those commitments were documented publicly. Over time, questions remained about the follow-through. Some participants continued to ask about refunds and unresolved concerns. Coffeezilla continued to press for clarity. Eventually, instead of settling the dispute through repayment or further clarification, the situation escalated into litigation. That lawsuit led directly to the deposition that is now at the center of this debate. A deposition is a different environment from a social media platform. It is structured, it is formal, it is conducted under oath, answers are given in real time, recorded word for word. There is no editing after the fact, no retakes, no added context in the description box. It becomes a permanent transcript of exactly what was said. If that transcript aligns smoothly with prior public statements, it can strengthen the case. If inconsistencies appear, it can create complications. That is why depositions often carry weight beyond the immediate lawsuit. They can influence related proceedings and shape broader legal strategy. If the deposition had clearly reinforced Logan's public narrative, there would likely be less urgency around sealing it. It could serve as a supporting document. It could be cited as proof of consistency. Instead, the focus is on preventing its release altogether. Coffeezilla's legal team emphasizes this in their response. They argue that Logan has not presented a concrete, good faith basis for sealing the transcript. Without specific examples of confidential content, the request remains broad and unsupported. At this stage, the debate centers on a simple legal principle. Transparency is standard. Secrecy must be justified. And until a clear, legally recognized reason is provided for sealing the deposition in full, the question remains whether this effort is about protecting sensitive information or managing the potential impact of sworn testimony. He has not explained why any specific portion of the deposition qualifies as confidential under the protective order, not a paragraph, not a sentence, not even a single example that clearly meets the legal definition of protected material. Instead, the request is sweeping. Seal the entire thing. Remove it from public view completely. That approach does not usually align with how courts operate. Judges expect precision. They expect clearly defined reasons tied to established legal standards. A broad request without detailed justification rarely meets that bar. When you zoom out and connect all the pieces, the larger picture becomes harder to ignore. This does not look like a fight over private medical data or sensitive family information. It looks like a fight over reputation, over branding, over narrative control. The tone of this case has shifted. It no longer feels centered on whether criticism crossed the legal line. It feels centered on whether sworn testimony could complicate a carefully managed public image. Logan did not end up in this position by accident. Public statements were made about addressing issues connected to CryptoZoo. Refunds were discussed. Commitments were announced. Those promises were documented in widely viewed videos. As time passed, many supporters and critics alike continued asking about follow-through. Questions remained. Pressure did not disappear. Eventually, the dispute moved from online commentary into the courtroom. That legal escalation led directly to a deposition. And a deposition is different from a podcast appearance or a social media upload. It is structured. It is formal. It is recorded word for word under oath. There are no retakes, no editing afterward, no opportunity to reshape phrasing once it is said. What is spoken becomes part of the record. If that record strongly reinforced prior public statements, it could serve as validation. It could strengthen credibility. It could close the chapter. But the push to seal it entirely signals concern about how it might be received if released. Because once a transcript is public, it stands alone. No framing, no selective clips, just context and consistency, or lack of it, preserved on paper. And this is why the court's decision carries weight beyond this one motion. If the request to seal is denied, the transcript could influence related disputes, ongoing claims, and public perception. If it is granted, questions will still linger about what prompted such a broad confidentiality request in the first place. Either way, the outcome shapes the next chapter. At its core, this moment highlights the tension between influence and accountability. Internet fame offers control over messaging. Legal proceedings do not. When those two worlds collide, transparency often becomes the central issue. So now the question moves beyond the courtroom and into the public conversation. Should sworn testimony in cases like this remain private without specific justification? Or does transparency better serve the process? Share your thoughts in the comments. If you want more breakdowns on influencer lawsuits, accountability battles, and what happens when online fame meets real-world consequences, make sure to like this video, subscribe, share it with someone following this story, and I will see you on the next one.